We can get started. Thanks for joining us today, everyone, for this installment of Women in VC. There are some familiar faces here and some new faces. For those I don't know yet, I'm Meredith Beuchaw. I'm a partner in the tech group at Lowenstein. I'm joined by a few of my partners. Alyssa and Chandra are also corporate partners in the group. Lesley, Sophia, and Kristin are our tax experts. And this series started because we were getting a lot of great questions from women who didn't want to fake it so much in the boardroom. And we see people faking it a lot. And we have a lot of respect for our clients who come to us and say, make us smarter. So none of the materials we're going to cover today or any day are gendered. We teach the same thing to men, but we loved that women were coming to us with questions and wanted to provide a space where more questions could be asked and answered. We've done some general topics. We've done some subject matter specific topics. And to me, today is the big subject matter specific topic in that it's a real driver of deal structures for VCs and for venture-backed companies. And it's really intimidating to a lot of our clients and frankly, to a lot of our younger lawyers. Once you get your head around it, I mean, I'm not going to pretend to be the expert Lesley, Sophia, or Kristin are, but getting your head around it demystifies a lot of the choices that are made in venture capital. So we're really excited to have Lesley and Sophia and Kristin talk us through some of the big themes that come up a lot for venture-backed companies and their investors. So with that, I'm going to turn this over to Lesley. Alyssa, Chandra, and I will chime in with what we see on the corporate side throughout. Feel free to put your questions in the chat. We'll try to get to all of them, but if we don't, we can reach out one-on-one after the hour's over.
Yeah, thank you. So I'm Lesley Adamo. I'm vice chair of our tax practice here at Lowenstein, and just our tax practice is very broad in general, right? So we work with many VC companies and founders of VC companies. We work with the portfolio companies that they invest in. We work on tax issues specific to startups that are just starting, and tax issues specific to very big companies. We do small M&A, big M&A, and we do a lot of personal tax planning as well. So, you know, we are generalists and we can answer lots and lots of different types of questions. And we've seen many different issues that come up in all sides of VC transactions. So we're excited to hear talk about some of the key tax considerations for funds, their founders and operators. Next slide. So what we're going to cover, or what we're hoping to cover next, is firstly, qualified small business stock. Right. So many people in this room might have heard QSBS with that term thrown around. Sophia is going to take us really through what is QSBS, how do you get the benefits of QSBS and all things QSBS. We're then going to move to tax considerations and venture capital financings, talk about secondary sales, and hopefully we're going to have time to also talk about VC compensation, since we have some women in VC in the room. Okay, so with that, I'm going to kick it off to Sophia to start with qualified small business stock.
Great, thanks, Lesley. So I guess high level, just as a really baseline introduction, qualified small business stock refers to a section of the tax code, section 1202, as tax lawyers tend to talk in code sections. So you might hear 1202 a bunch today. And under that section, basically provides a special incentive for non-corporate shareholders of C Corps who acquired stock directly from the company. And so the code basically provides that in certain circumstances, the stock of the C Corp is qualified small business stock, and with the right holder, with the right business, and if held for more than 5 years, then the stockholder can exclude a portion of the gain from the sale of that stock. There are no special tax filings needed, but there are a lot of really detailed requirements to get this benefit. QSBS is exciting because sellers can exclude from their gain the greater of 10 million or 10 times the seller's cost basis in that QSBS. And we'll go through an example in a few slides of just how that really plays out. And so it is a big driver in when funds invest in companies and want to make sure that they preserve that benefit and that they structure for that benefit. We see it as a big motivating factor and consideration in sale transactions and M&A. Founders want to make sure that they can get this benefit and that the transaction structure doesn't impact their ability to get this benefit. So hopefully we'll give you some insight into some of the requirements, some common traps that we see. All right, next slide, please.
And Sophia, one thing I just plug is, especially for those of you who are at early stage companies or are early stage investors, making sure the companies you're investing in have good counsel in some way that's familiar with this is really important, because they can do things early on that can mess this up for you. And catching it as soon as possible is so important. But if nobody around the founder understands or knows what this is, it's easy to have a footfall.
Yeah, and we'll go through some of those common examples that we see as well as we go through these slides. So just one caveat. So qualified small business stock in section 1202, these are federal tax code references, and we're really talking about federal income tax concepts today. But we didn't want anyone to forget state and local taxes. So there are, different states have different rules. We're not going to go through the details today, but figured we'd flag that for the group. All right, next slide, please. So we're going to walk through an example that will hopefully illustrate sort of why this is such a valuable benefit that can be a really big driver in a lot of ways. So in this example, we have the formation of a company by the founders in 2017. The founder put in 10,000 of cash into X Corp. X Corp is a corporation for US tax purposes. A year later, the Series A round, a VC fund comes in and invests 2 million in cash into X Corp. And then, a few years later, there's an exit. And the exit is structured as a sale of 100% of the stock of X Corp for $100 million. So for the founder who put in 10K of cash originally, their gain on their 40 million of deal proceeds is 39.99 million of gain, right? That's taxable income basically. With QSBS exclusion, their limit would be 10 million. They would basically get to exclude 10 million of that gain from tax. So that's 10 million of gain that they don't have to pay tax on. For the VC fund, because they actually put in more cash to begin with, their exclusion is actually 20 million. So here you can see sort of why this is such a big driver. Obviously, not paying tax on 10 million of gain, not paying tax on 20 million of gain is a really valuable benefit.
And just I'll add there, one of the reasons VC funds are so focused on QSBS is because their investors can get the benefit on an investor by investor basis, right? And so it's not that the total benefit, if a VC fund invested 2 million, there'd be 20 million of potential exclusion if you looked at just what the VC fund's basis was in the stock. It's a little complicated, but essentially there could be a circumstance where every single VC fund investor could get a $10 million personal exclusion on the gain or their portion allocated to them, right? Just because of the way the tiering of the rules work through tax partnerships. And so VC funds are often really focused on this because if they can pass QSBS benefits through to their investors can really, really juice their gains from those exits that the VC fund is making. And that's one of the reasons this is so focused on by funds. The fund managers who have carry also can potentially get the benefit through the carry they hold in the fund as well, even if they're not investing significant capital. And so there's ways to basically multiply the exemption when a VC fund is investing in a portfolio company and getting QSBS benefits.
And obviously there's a lot of sensitivity on the other side, because there is all this benefit, funds tend to be really conscious of making sure that there aren't the foot faults to make sure that they preserve this benefit or, the potential benefit for their investors. So the next few slides, as I mentioned, section 1202 of the code has a lot of different requirements, both at the company level. So X Corp has to meet various requirements, but also there are a lot of requirements at the shareholder level. So we're not going to go through all of them. We're going to highlight a few and go through some examples and sort of highlight common issues we encounter. So this slide is who can hold QSBS, and this is a shareholder level requirement. So not everyone can get the benefit of QSBS. This is limited to investors other than C corporations or stockholders other than C corporations. So individuals, partnerships, LLCs that are not corporations, and even S Corps, though we can talk more about that later. All right, next slide. Now, this slide addresses a few more of the requirements. So in order for X Corp, in our example, or a company to issue stock that could be QSBS eligible, as I mentioned, there are some company level requirements as well. So the company that issues the stock has to be a C corporation. We'll get into some of the nuances with S Corps, but this is sort of why we see a lot of startup companies formed as C corporations very early on. The issuing corporation has to be a qualified small business. We'll get into some of the details of what that phrase means. The stock has to be purchased at original issuance. And so basically what this means is in primary investments, QSBS cannot be purchased in a secondary. So if one shareholder purchases stock from another shareholder, that stock cannot qualify for QSBS in the hands of the purchasing shareholder.
Just to interject a quick note, Sophia, I hear often founders will issue themselves all the stock in the corporation. And then sometimes when they are bringing on key new hires or even a co-founder level person, will need to get stock to those new people. And the answer is usually not to transfer stock that's already been issued to those people for this reason, because it would not qualify as QSBS. But that's something that people often try to do. So it's important just to think about QSBS from the very beginning.
Yep. Another requirement, and here we're talking again about the company level, is during the holding period, the company has to meet the active business requirement and, continue to be a C Corp, obviously. There are some nuances where, a company can start out as an LLC or a partnership and then convert to a C Corp at a certain point. And when it does convert to a C Corp, that stock can be QSBS and actually, increase the amount of the potential benefit in that situation. But it's just something to keep in mind if you are formed as a partnership or an LLC and you are looking to convert, to keep in mind the QSBS requirements to make sure that that conversion makes sense.
And I think just real briefly too, if you encounter an S corporation looking for financing and you're thinking about investing, or you're a founder that holds through an S Corp, there are some additional steps that need to be taken to restructure to get the benefits of QSBS if they're available. So that's definitely a circumstance. If there's an S Corp, you need to speak to a tax lawyer who actually knows about QSBS. So you could talk about potential QSBS structuring, because we see a lot of misadvised companies in that area.
Yeah, and that it's also a good example where, just because the investors who are coming in might qualify for QSBS because it won't be an S Corp when they buy the stock, their interests aren't necessarily aligned with the founders who, when they were issued their founder stock, it was still an S Corp. So, it's just something to keep in mind that just because one party gets QSBS stock, it doesn't mean that all the shareholders necessarily get it.
Yeah, and there's ways to potentially plan into everyone actually getting the benefit as well.
All right, next slide, please. So we'll start off by talking about what's a qualified trader business. And again, we're talking about a company level requirement. So the code defines it by what it's not actually. And so they tell you what's not a qualified trader business. And what's not a qualified trader business is the performance of services in the fields of health, law, engineering, architecture, actuarial science. I won't read through all of these. Banking, insurance, financing, leasing, investing, and other similar businesses, farming, and any business operating a hotel, motel, restaurant, or similar business. While this seems very straightforward, as I'm sure you can imagine, when this code section was implemented, there wasn't as complicated, there wasn't as much of a tech space as there currently is. And so now we see a lot of questions about whether businesses are operating in the qualified trader business, because what is a financial service? How is that defined? While the code has some guidance and the IRS has released some guidance, there is a lot of gray area for these, and it's just something to keep in mind. So,
and I think the big one we see, Soph, is fintech, right? Like that's one of the big ones that we've had to deal with a lot historically. So we have fintech clients or VC funds investing in fintech, and they are asking, is that financial services or is that technology?
Yeah.
Right. And so we actually have a whole side opinion practice about trying to get to the answer of that, and spending a lot of time working with investors where it's real dollars or potential real dollars to give them, some comfort on what the answer is, right? And try to get them that answer they're looking for.
Yeah,
and
another area where we see a lot of ambiguity is med tech businesses, particularly platforms that end up connecting medical services to actual individuals.
Yes.
And so while this is, QSBS is a benefit for a stockholder when they sell stock, but we oftentimes see it as a big priority of, our clients that are the company themselves, because, the founders want to get QSBS and they want to have answers for when their shareholders ask them about the QSBS status of the stock. So it's an interesting mix between sort of company level requirements, even though the company doesn't actually get a benefit, and shareholder level requirements.
Yeah, and I think that dovetails nicely with something we're talking about later, but I think maybe we just bring it up now. When an investor's investing into a company, like a VC fund's investing into a company, oftentimes what they're going to ask for are representations from the company as to its status as a qualified small business, right? Is it QSBS eligible? And it's going to, the VC fund often has a checklist, right? We give lots of our clients checklists to work off of. The model NVCA docs have a checklist also attached to them, that some people work off of to try to figure out whether the company is possibly qualified. We always will tell our clients, especially VC fund clients, you should do your own inquiry, like ask the questions of the company, and don't just go off of what their initial reaction is, because it is somewhat of a nuanced analysis, and you have to be very well advised to answer the questions and to even ask the right questions, right? And so this is something we often see in negotiate, when people are looking to invest, they're asking all these types of questions. Are you in a qualified trader business? What exactly are you doing? Who have you talked to about this, right? And that's the time where this really starts getting sussed out, is really even at the initial early stages of diligence.
Great. So next slide, please. So we've gone through a few of the requirements. Like I said, we're not going to go through all of them here, but I think we're going to jump now to a topic of where we see a lot of issues come up over the life cycle of a company, and the different transactions that a company might undergo. Certain redemptions can disqualify the stock that was issued near in time to that redemption from QSBS status. It can get a little complicated, but there is a disqualifying redemption rule that relates to the stockholder that is actually being redeemed. And so there we have a 4-year window. So you look at redemptions that occurred, 2 years before and 2 years after that stock was issued. And there you're really focused on whether or not the stock of the redeemed party and their sort of certain related parties, whether their stock is disqualified. I think the bigger issue that we see are significant redemptions, because sometimes a redemption of one shareholder can impact the QSBS status of other shareholders who are not participating in the redemption at all. Next slide, please. So there are some exceptions to the redemption rules. This is the analysis that we are typically asked to look at when a company is considering a redemption, a repurchase of its stock for a certain amount of cash. You know, this is the driver for some of the questions that we're going to ask. The interesting thing here is, you know, these requirements look at how much is being paid for the stock that's being redeemed, but it also asks about the value of that stock, right? So if those two numbers don't necessarily match, that's sometimes an issue that we see. And it also looks at the value of the stock outstanding at the time of immediately prior to the redemption. So all of the stock outstanding, how much is that worth? An issue that we see a lot here is how you calculate what the value of all the outstanding stock is at that time. We typically view this as, you know, taking the fair market value of each class of stock and each share of stock, and aggregating that number. And so it may be different than, you know, a post-money valuation that might have recently been received. So there's different concepts of value that might come into play here.
Yeah, and I think the practical point that we always make to our company clients is please don't make any redemptions. Call us. Always, never, ever make redemptions before you talk to a tax person, because even a redemption from someone for very de minimis amounts might later disqualify a later redemption just because the way these aggregation rules work. This also is implicated in weird ways that you wouldn't expect. Like I just had one of my partners ask me about an investor who got a loan from the company and secured it with his company's stock, and then he defaulted on the loan. Now the stock has to be forfeited. And luckily my colleagues in the tech group know that might cause a QSBS issue, and they called and asked me, right? And they're right that there's a QSBS issue there, even though you wouldn't expect it. And so anytime there's any stock that's ever being redeemed or forfeited, you have to call tax to ask about whether there's a 1202 issue. And on the VC fund side, when you're doing your diligence into the company to see whether it's a good QSBS business, disqualifying redemptions is like one of the number one things you're actually diligencing, because it could totally disqualify your investment from being good QSBS, even though it's a transaction that happened in the past 12 months before you invested.
And it's not just backwards looking. I think as an investor, you also have to be concerned about going forward for the year after, you know, you receive your stock, making sure that or you have some control about whether or not the company makes redemptions in that period as well. So it's both backwards looking and forwards looking. You know, some of the more common exceptions to this rule that are applied, a redemption in connection with the termination of services by an employee or director, or the death of the stockholder, in certain circumstances, will not be a disqualifying redemption. The point we really like to emphasize here is that, you know, the code just addresses termination of services by an employee or director. There isn't guidance on independent contractors necessarily. So, you know, oftentimes we'll want to dig in to make sure that the redemption is really happening in connection with the termination of services. Are they continuing to provide services afterwards? You know, there can be a lot of gray areas that come up. Great. Next slide, please. So this isn't just for investors, as we mentioned, it's for founders. It's also for employees who receive stock grant through employment. For restricted stock awards, the point we like to highlight here are 83B elections. Basically, by filing the 83B election, you're starting your QSBS holding period, which is 5 years. So if you don't file your 83B election, then your holding period won't start until stock vests. So that's something to keep in mind. With options, options don't qualify for QSBS on their own until they are actually exercised and the employee actually receives the stock. So that's, an important point for thinking about your holding period, meeting the 5-year holding period requirement. It won't start until the option is exercised. And if there are any restrictions on that stock after exercise, you'd need to file an 83B election again to start your holding period.
Yeah, and I think one issue we commonly see are founders need to rebalance stock holdings across the cap table. So like 2 people started a company and they had a 3rd co-founder and they kind of forgot to issue them stock and now they need to issue them stock, right? That's like actually a fairly common fact pattern we have. Oftentimes we'll want to have a big conversation with that 3rd co-founder about, hey, maybe you should buy stock with a loan or otherwise be issued restricted stock and find a way to pay the tax on it and make the 83B election so that you make sure you could have good QSBS. I mean, among a million other considerations that go into it, but that is one of the factors we often talk to our clients about when that happens.
All right, so I think in the interest of, next slide, please. I think we're going to kind of speed past some of these next few QSBS slides to get to some of our other topics. But what we really want to highlight here is that, as Lesley kind of highlighted in the initial example, right, where an investor is investing through a partnership, an S Corp or an LLC that is not a C Corp and looking to get QSBS status, there are a lot more requirements and a lot more footfalls. So, it's evaluating where the QSBS requirement is assessed at the partnership level versus, the member in that partnership. So just figured out that there is a lot more complication there.
And I think if you're someone who's sitting on a board of directors and you're being asked to approve things like redemptions or loans for people or forfeitures of stock or anything really like that, you should keep this in the back of your mind and ask the question of whether, management has talked to someone from a tax perspective about impacts here. And it may be totally fine, but it's always worth asking that question.
Yeah, absolutely, Chandra. And I think also if you're looking at a portfolio company and you're evaluating whether you want to make the investment, you're looking at all the possible benefits, QSBS should always be something in the back of your mind. And if the company hasn't done the analysis, it's something you should ask them to do, and you should get your own counsel to help you do it. And also, if for whatever reason they don't think they're eligible, you should also have someone do the analysis for you and see if there's a way the company can restructure, or if maybe their counsel's missing something that could possibly still get you QSBS, because we see that happen all the time. Before we go to financings, I want Kristin to talk for a few minutes about 1045, because this is a really great tax benefit that not everyone is aware of.
Yeah, that's slide 17.
Thank you.
Great. So thank you, Lesley. So as Lesley said, we're now going to look at a situation where there's an exit event before your 5-year holding period has been met. In that situation, Section 1045 can allow you to defer gain on the sale of QSBS, where those sale proceeds are rolled over into replacement QSBS. Now, in order to qualify for this rollover treatment, your original QSBS has to have been held by you for more than 6 months. And unfortunately, this doesn't take into account any carryover or tax holding periods that may apply for other tax purposes. So for example, if you acquired the QSBS pursuant to a tax deferred exchange or a reorganization less than 6 months prior to that sale, you wouldn't be eligible for this benefit. In addition, you have to make an election to apply Section 1045 on your tax return for the year in which your original QSBS is sold, and you have to acquire that replacement QSBS within 60 days of such sale. So it's a very tight time frame. And often, it's something that you want to be thinking about and really exploring and identifying that replacement QSBS while you're negotiating the sale of your original QSBS, so you don't miss that window. You should know that there is some additional complexity where QSBS is held through a partnership. Now, at a high level, if the partnership has held QSBS for more than 6 months prior to the sale, either the partnership itself or certain eligible partners can reinvest QSBS proceeds via a rollover. And this rollover can even, in some cases, include the contribution of your sales proceeds to a new partnership, as long as that partnership uses the funds to acquire new QSBS within that 60-day window. So there can be a lot of planning advantages if you have it in mind as you're entering into a transaction in which QSBS is going to be sold before you're able to benefit from the full exclusion because the holding period isn't met. One thing I do want to flag is that holders of carry or profits interest generally are not going to be treated as eligible partners, and so often don't really benefit from these rollover rules, because Section 1045 focuses in on the smallest capital interest that is held by a particular partner during the holding period. And profits interest holders usually have no or only a de minimis capital interest.
Yeah, the great thing about 1045 and where I've seen it used most is by founders. So let's say a founder has a great startup and they've only held the stock for 4 years and VC fund really wants to sell, right? And so the VC fund is pushing for the sale. The founder doesn't want to do it because he knows he only has 6 more months on his fund. Let's say he's held it for 4.5 years. VC fund doesn't care about QSBS. They've only held it for 3 years, let's say, and they invested when the company's worth too much. One thing the way the VC fund can use 1045 to their advantage, they could say to the founder of the company, hey, listen, yes, your stock today might not have been held for 5 years, but if you roll any of your proceeds into another startup, you can continue to defer the gain and not have to recognize it right away, right? The founder, on the other hand, could be thinking the same thing. This is great. And we have a lot of founders that do this. If they sell their company before the 5-year holding period, they can roll their proceeds into, or half of their proceeds, whatever it is, into another startup. And the great thing about that is if that new stock is QSBS eligible and continues to be, the holding period from the first company taxed the second. So we had a client recently who did sell at the 4.5-year mark. He rolled his proceeds into another startup that actually he had the idea for within 60 days. He formed a new C Corp. He funded it with the proceeds from his old company. He deferred all of the gain, right? And now he's already held that stock for more than a year. So anytime he now has an exit from his other company, he gets QSBS benefits, right? Even though in his new company, he's held the stock for less than 5 years. So 1045 is a really neat provision. The only caveat is you have to know about it, which it's like a big secret. And you have to just plan before your exit to have a new investment lined up within 60 days. Okay, next slide. Okay, so we're going to move to venture capital financings. So there's a bunch of different ways that VC funds invest in companies, right? They can just buy stock, they can buy debt. The debt could either be convertible debt or not convertible debt, or they can invest via derivatives, right? Like a prepaid forward, or they can invest via SAFE. And what is a SAFE? What category does that fall in, right? That's a whole topic of conversation as well. What instrument should be used to invest in a portfolio company is primarily actually an economic question, right? Like, what are your economic goals? Tax should not be the ones primarily driving the conversation here. The first question is, what are you looking to get out of your investment? Do you want to share in all future value, right? Like really have equity and share in all upside? Or are you looking for return of your capital and some capped return? So really having something like debt. Or maybe a hybrid, maybe you want debt and some warrants, right? Those are all different types of investment instruments you could be using into a company and economic goals you could be trying to meet. From a tax perspective, the big questions are, 1, will I get long-term capital gain, right? If you're an investor, and 2, will I get QSBS? Investors want to pay as little, and founders, anyone selling equity wants to pay as little tax as possible on an exit, right? And the question is how to do that. And it's either long-term capital gains rates, right, which are on the federal side, like 17% lower, or qualified small business stock, which means you get to totally exclude from income a big chunk of cash, as Sophia went through. So the question is, how do we get you there from a tax perspective once we understand your economic goals? So the first couple slides just have to do with common provisions that are asked for in financing agreements regarding QSBS. So the fact-based representations, right? So how do you make sure the company is QSBS eligible? You're often asking in the SPA for representations as to the QSBS eligibility. So there's different permutations of that. Next slide. There's also certain covenants often appearing in either the investor rights agreement or purchase agreement about provision of information, so the investor can determine the QSBS eligibility, or restrictive covenants, the investors asking the company not to do things that would cause them to lose QSBS status. So these are just common provisions that help protect QSBS treatment. You can skip to slide 23. I'm going to focus for a few minutes just on one of the most common financing instruments we see, the SAFE. Now, I think everyone on this call has probably heard of SAFEs, simple agreements for future equity. And SAFEs are really interesting, right? They were introduced by Y Combinator in 2013, so they've been around for about 10 years. And they were really meant to replace convertible notes, right? And they were seen as kind of like a better version of a convertible note because there's not a maturity date. They convert only in the event of an equity financing or company sale, but they don't bear interest, right? So there's an investor preference for equity upside in these instruments without all of the difficulties of dealing with actual debt. They're better than a priced round because they're cheaper, right? And so a lot of times people are using SAFEs in between priced rounds. They're using SAFEs where they used to use convertible debt. There's two different forms of a SAFE. There's what we call the old form and the new form. The old form's a pre-money SAFE and the new form's a post-money SAFE. And the big question from a tax perspective is, what are they from a tax perspective? Are they debt? Are they equity? Are they a derivative? Do we know? Does anyone know? The answer is that the IRS has not come out with guidance on what they are, but we have a way of finding out what a good position is with respect to these instruments. You can skip to slide 25. So common terms of SAFEs, right, which I think everyone on this call is probably familiar with, is that the investor is paying a purchase price for the SAFE. And then when there's a subsequent equity financing, the SAFE basically converts into a certain number of preferred shares based on the value of the company at the time it's converting. Some SAFEs have valuation caps, some have discounts. So at the time that you're investing into a SAFE, you don't actually know how many shares of stock you're going to get, right? And what the terms of the stock are actually going to look like. You're going to end up converting into whatever the price round instrument looks like. The new form SAFE is different than the old form SAFE, and that it's determining it's based on a post-money concept. So when you're calculating how many shares you're converting into as an investor, it's based on a post-money valuation rather than pre. From a tax perspective, that's not the interesting part. From a tax perspective, what's interesting is what they changed in the new SAFE is that they included a term that essentially gives the SAFE holder a right to dividends if a dividend's ever paid, although we all know dividends are never paid while SAFEs are outstanding. It also added the Y Combinator added a tax paragraph to the new form SAFE that says for tax purposes, despite the form of the SAFE, it is stock, specifically for 1202 purposes, right? The QSBS provision Sophia just talked about. These provisions are really interesting because what they did is the Y Combinator tried to add into the post-money SAFE language to help clarify the tax treatment and say, look, everyone's agreeing we're going to take the position this thing is stock, primarily so investors could start their holding period for both long-term capital gain and, more importantly, QSBS. Whether or not a SAFE would actually be respected as stock by the IRS is an open question. The IRS has not provided guidance on the typical form safes we see. We always take the position that you have to look, that your tax advisor has to actually look at the terms of the safe and advise you as to whether they think there is a good position. It is stock versus a variable prepaid forward contract, which would be the alternative treatment. The reason we can't say blanket all new form safes are stock for a tax, from a tax perspective, and all old form safes are variable prepaid forwards is because it's actually the facts surrounding the issuance that are very important for a very complicated tax analysis that I'm not going to bore you with. But also, many times people doctor the safe themselves. So we see time and time again, companies telling us they use the Y Combinator form safe. But once we actually read the safe, a bunch of terms have been changed, which actually make the tax treatment even look more like stock or more like a variable prepaid forward. So we always do have to read the safe if you really want to get more assurances as to what the likely tax treatment of the safe that you are particularly investing in would be. But one thing to always check, especially if you're not getting tax advice when you should, is to see if your safe has tax language in it, right? And it is always helpful if there is tax language, at least declaring what the intent of the parties is as to the treatment of that safe. One issue that you can get into with safes and not having clarity, oh, sorry, next slide, and not having clarity around the tax treatment is you want to be in agreement as an investor with the company, and the company wants to be in agreement with the investor as to the tax treatment of the safe. And the reason is, again, this QSBS position, where this most often, when the tax treatment of a safe most often becomes an issue, is where an investor invested in a safe, 2 years later, the safe converted into stock, and then 3 years later, there was a sale of the company. The question from the investor is always, help me prove out I had good QSBS from the moment I invested in the safe. And the investor, so often the VC funds, counsel then is stuck looking backwards and saying, oh my gosh, what were the facts around their original investment? Does it look like that safe actually could be stock from a tax perspective? Did it have good language in it? What were the facts surrounding its issuance? What are the conversion metrics in the safe, right? So there's a lot of questions that go into it, and it's always better not to be making these determinations 6, 7 years down the road, right? It's always better to have contemporaneous documentation for your good tax position from the moment of your investment. And so as a VC investor, you want to start having that documentation lined up when you make your safe investment, right? You do not want to wait till your exit. And that's, I think, a bigger point for QSBS positions generally. What we often see from our VC investor clients is they're exiting a position and they say, can you help me analyze and document that I had a good QSBS on the sale transaction? And if we haven't been involved from the moment that VC fund invested in the startup company, we might not have all the information we need to do the good QSBS analysis, right? So proving out that the company was engaged in active trade or business for all 5 years, and proving out that it was always in a good qualified small business and didn't have too much working capital, and that there weren't disqualifying redemptions. It's really hard to ask many companies to go back 7 years or 5 years, 6, 7, and prove out all these facts. So just generally, it's always so much better if you're not making a huge backward-looking inquiry to prove out these good tax positions. I'm not going to go too much into other types of investment instruments. The one note I would say, and an issue we often see for VC funds, is convertible debt, right? So if you're using a convertible debt instrument to invest in companies rather than a safe, convertible debt is interesting. From a tax perspective, many venture debt actually just looks like stock or a safe, a variable prepaid forward, from a US federal income tax perspective. And sometimes we even see convertible debt instruments with a little paragraph in it that says, for tax purposes, everyone's going to treat this convertible note as stock from the date of its issuance. And sometimes that's a really favorable provision for an investor to have in the convertible note. Sophia and I had an issue with a client a couple of years ago where they found us and said, hey, we hear you know a lot about QSBS. We have a QSBS question. And their question was, we had a convertible note. It converted about 2.5 years after our investment. And 3 years later, we had big exit, and they exited for many, 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 many times the size of their original investment. And they said, did we have good QSBS stock? And so the actual question was not even a QSBS question, right? The actual question was, well, was their convertible note QSBS stock and not really debt? And the terms of the note are so important. So many convertible notes actually look just like stock and maybe just like preferred stock if you actually read the terms. So convertible notes are really interesting. And as an investor, you really should get tax advice anytime you're investing in a company via convertible note, because the terms of the note could be such that even if you want a note because it gives you more creditor protection, that there's some little tweaks you can make that give you also really beneficial tax treatment. And it's not too late if you've already invested via some convertible notes and you need someone to weigh in on whether they really are debt. We're happy to look at them for you. But that's just a plug for convertible notes and considerations you need to give if you're investing via a convertible note. Okay, so I think one other topic we want to talk about is investment into foreign portfolio companies, because we see that quite often.
Yeah, absolutely. Thanks, Lesley. If we could go to slide 30, that would be great. Thank you. So when evaluating an investment in a non-US corporation, there are two key anti-deferral regimes to consider, namely the Controlled Foreign Corporation or CFC rules and the Passive Foreign Investment Company or PFIC regime. At a high level, CFC and PFIC issues can be very costly and disruptive, but advanced planning at the investment stage can mitigate or even eliminate most of these issues. So it's very important when you are considering an investment in a potential portfolio company that is based outside of the US that you get US tax advisors involved at the negotiation stage. In addition, local counsel may need to be retained to address tax filing obligations in non-US jurisdictions, as well as non-US withholding considerations, which can sometimes be mitigated or eliminated if there is an applicable tax treaty. Next slide, please. So first, under the CFC rules, a US shareholder that meets certain ownership requirements has to include in its income its share of certain types of income generated by the CFC, regardless of whether distributions are made by that CFC. So it's modified pass-through treatment, as though you're invested in a partnership when you're dealing with a CFC. In general, a foreign corporation will be treated as a CFC if it's more than 50% owned by voter value by US persons who each own 10% or more of the total voting power or total value of all shares of all classes of stock. I do want to note that ownership for this purpose can be complicated to determine, as there are indirect ownership rules, and there are also a number of attribution rules that can apply. The most confounding of which is downward attribution, pursuant to which a US entity in which a foreign person is an owner may be considered to own the stock of a foreign corporation that that foreign person owns directly. So this kind of attribution is most often an issue when you're looking at a holding company structure where there are both US and non-US subsidiary entities. But long story short, you generally are going to want to involve a tax lawyer to conduct an ownership analysis when there is significant US investment already in a non-US corporation, because looking at the cap table alone is often not enough to really determine whether CFC rules are going to apply to your investment. So let's move on to the next slide, where there are a couple of examples. And these are simple examples showing how ownership can be determined. So the first one is very straightforward. This just shows direct ownership. In that first example, Foreign Corporation A is a CFC because it's 60% owned by a single US person, Fund A. In the second example, we're looking at indirect ownership. Fund B, because it is not a US entity, is looked through. And as a consequence, each limited partner is treated as owning 10% of the stock of Foreign Corporation B. And Foreign Corporation B will be a CFC if more than 5 of the limited partners are US person, assuming that they're not otherwise related to each other. Next slide, please. So once an ownership analysis has been conducted and it's been determined that this prospective investment is a CFC and you will be a 10% US shareholder, it's very important to negotiate as part of the deal responsibility for the preparation of information that you're going to need to comply with your reporting requirements. This essentially is going to require the portfolio company to maintain books and records in accordance with US tax principles, which they likely otherwise would not be doing. So there needs to be a discussion of which party is going to be performing this incremental accounting work, as well as who's going to pay any associated costs. And these issues really should be addressed explicitly, either in the stock purchase agreement or investor rights agreement through covenants, or through a side letter at the time of the initial investment.
And I'd say the market's definitely like, there are now kind of market terms for what VC funds always ask for in regard to investing in PFICs or CFCs or potential PFICs and CFCs. So if you have a law firm who's seen this before, the negotiation usually isn't too bad, just because everyone kind of knows what the provisions are going to look like and know what to expect, and the negotiation's fairly streamlined.
I agree with that. I would say, though, that it is something where you should consider putting it up front in the term sheet when you are doing a transaction. I mean, certainly, like Kristin said, it needs to go in all the places in the operative documents, but thinking about it at the term sheet stage is important, because a lot of times there's some education around it that has to happen, especially if it's a first round for the company. And it may actually ultimately impact structure if the company does eventually plan to flip up into like a Delaware corporation, for example. This may be something that they decide to just do it now rather than waiting. And so it's worth thinking about early and talking to someone early, even at the term sheet stage.
Thanks, Chandra. Yeah, completely agreed. And then moving on to the next slide, even if a prospective investment is not going to be treated as a CFC once you've done your ownership analysis, or you would be a less than 10% shareholder, it's still important to consider whether the PFIC rules may apply. So under these rules, a non-US corporation is going to be a PFIC if either 75% or more of the foreign corporation's gross income is passive income, or 50% or more of the foreign corporation's average value of its gross assets consist of assets that are expected to produce passive income. Now here, since cash is treated as a passive asset and interest is treated as passive income, for purposes of these tests, non-US startups are often going to be treated as PFICs. So the consequences of this are generally that a US person who directly or indirectly holds stock in a PFIC can typically choose either to elect to treat that foreign corporation as a qualified electing fund, or QEF. Apologies for the alphabet soup. That's just international US cross-border tax, lots of acronyms. And if a QEF election is made, that person is effectively treated as a pass-through holder with respect to ordinary income and net capital gains. So similar to a CFC situation, there's a modified pass-through of ordinary income and net capital gain on an annual basis, regardless of whether or not distributions are made. The other choice is to not make a QEF election and be subject to the default rules. Under these default rules, generally, you pay tax only when distributions are actually received or when gains are realized on a sale of stock. But this comes at the cost of potentially very significant additional tax, most notably the conversion of what would otherwise be capital gain taxed at lower rates to ordinary income on the sale of the stock. as well as the imposition of a punitive interest charge. In my experience, most VC investors are going to choose to make the QEF election. Let's go to the next page to just look at a couple of examples. So in the first example,
Kristin, in the interest of time, I might want to just say like 2 or 3 things about secondaries and
absolutely. Yeah.
Three.
Absolutely. Before we move on, sorry about that. Just as in the CFC context, if a U.S. investor has to get information on an annual basis from the PFIC, particularly to make the QEF election. So again, it's something that needs to be addressed as early as possible to ensure that you get the information that you need to preserve your tax treatment. All right, apologies. So moving on to secondaries. Let's move to slide 40 and just look at a common scenario. So we have a startup company that obtains VC financing. Hooray! The company gets cash and issues preferred stock to new investors. The founders hold common and they would like some liquidity. Maybe they want to put a down payment on a home or a new car now that they've finally made it past this huge threshold. The new investors, on the other hand, as we've discussed previously, want to incentivize the founders, but are also very focused on preserving their eligibility for QSBS benefits. The first and simplest alternative to structure a secondary transaction is to have the company use a portion of the investment proceeds to repurchase some founder common stock. For the founder, there is a risk that their remaining stock loses QSBS eligibility if the redemption takes place too soon after they acquired the stock. In addition, if the founder is redeemed out at the preferred price, which is often the case, they can be treated as receiving compensation, which is taxed at ordinary income rates and subject to withholder. On the VC side, if the redemption is significant enough under the rules that Sophia mentioned, it could compromise the VC's ability to claim QSBS benefits with respect to its entire investment. The company also has concerns, particularly with withholding. One option to mitigate some of these concerns is to have the redemption take place sometime after the initial investment, but to truly mitigate those concerns, the waiting period would have to be over a year, which may be too long for a founder to stomach. Another structure that we see is a secondary tender. Apologies. In that structure, the VC investor effectively splits their investment, acquiring common stock directly from the founder, as well as preferred stock from the company. From the founder's perspective, provided the structure is respected, they no longer have the risk of tainting QSBS eligibility with respect to the remaining stock, and their risk of being treated as receiving compensation is somewhat lower. But this comes at a cost to the VC investor, as the common doesn't have the same negotiated rights and protections as the preferred equity, and it's not QSBS eligible since it wasn't issued directly by the company. One trend that we have seen in this space is preferred investors buying common from founders at a 10% discount on the preferred, then exchanging that common and cash equal to that 10% discount with the company for more preferred, following which the company takes that cash and pays it out to the founders as compensation. The structure attempts to limit both the amount treated as compensation to the founder, while mitigating the risk that the VC investor will be unable to claim QSBS treatment with respect to the preferred that they acquire for cash from the company. It is important to note here, this is not a perfect solution. There is some risk that the structure is not respected, and the VC investor is generally still going to be unable to claim QSBS treatment with respect to the preferred that they obtained in exchange for the common stock. And I think we are well out of time, so thank you everyone for staying the last couple of minutes.
Yeah, before we drop, if anyone has any questions, we're available. So please reach out at any time. We do at some point want to talk about VC comp, good structuring, etc., tricks if you want to incentivize deal team members, all those good things. So we'll get those topics on another call. But yeah, please feel free to reach out to any of us should you have any questions about any of the things we talked about today, or if generally you have any general tax questions. We're always happy to talk, and we answer our phones. So have a good day, guys.
Thank you. Take care.